Okay, this is ChaYah Shalom, and I wanted to look at some of the materials that we have in the chat room that we have a study group, reconnaissance study group. So some of the members are able to put their files or contracts so that we can study them. And we're gonna invite some people that are in the study group and see if someone shows up. Hopefully, we have some people to show up, and we'll be able to post and share. Let's see, let me let everybody know. Okay, we are on. All right, so I'm letting everybody know. Whoever's on is on. Okay, we are on. Come join. So it kind of works out great when we have more heads than just one, especially if you've already tried everything on your own. It helps when you have
Okay.
your people. So we got some people coming on. This is AP. Hey, I'm gonna let you screen share and let's
Hey.
go over some of the voluntary contracts that are in the chat room. Hey, welcome. Hi.
Hello, I'm sorry. I'm sorry. I don't know. How do I do this?
Hi, Vivian.
Wait, I'm sorry.
What you trying to do?
What's that? No, I'm trying to. I didn't want to put myself on there, but
Oh, okay.
Okay.
oh, does it just come on like that?
You
Or
can
do I take it
probably
off?
take a look
What do
at,
you mean?
you
Oh,
know,
you have the
just
There you go.
you could block the video if you
Oh,
don't want, or you can mute yourself or whatever, or you can talk. But we're gonna let AP
there's a
no,
little video.
share contract.
There's a video icon at the bottom of the
there you go.
Okay.
Got it. Thank you.
So what we're gonna do, we only have about 30
Okay.
minutes. So what we're gonna do is put I'm gonna let you share the screen, AP, and we'll put the contract up there, and we can
I
go
have to get
over
an account.
some of the
There's
potential
like
violations,
no way we can get this done in 30.
and everybody else can mute unless they want to contribute to the video. So we're looking at a photocopy of an old car contract, and we've been just kind of surveying it, just skimming it, reading the little tiny itsy bitsy writing about credit life insurance and disability and gap insurance and optional service contracts, stuff like that, that are obviously all they were denied on this particular contract. They were all denied. So it said not applicable, NA, that's what that means. And so I've already noticed a couple of violations. What about you, AP? Do you see anything on there that's looking a little suspect?
I see some discrepancies with the finance charges and the other amount charges.
Like,
And
what do you see in particular?
I see a couple like this one here, personal injury, family or household, which they're charging you for it. Then the CFPB listed personal, family, and household items as essential, which you shouldn't be charged for.
Nice. Kind of nice that they have it right there, and it's double X'd right there in your face. But still, if we don't know going into a contract, if we don't know about these little tiny things, you know, they're just going to be like, bend over. Here we go.
Yep.
Yeah, shouldn't have to pay. Personal stuff.
Unless the charge is included, not the late charge, but there's something about this finance. There's something about these itemized charges that's like sending me in a loop.
They kind of go under federal truth in lending. They're like trying to make it look official as if they're really telling you where the money is coming from. They didn't. So that Title 15, 16.
Oh yeah, we did say that they're where did they get the money from if it was already financed?
Yeah.
You
And
know,
they're saying that they're under federal, like if you scroll up a little bit, it said it right there that this
credit or
is
something.
federal truth in lending disclosure. No,
Where's that at?
right there, right above
Oh, I
finance.
see it. The truth in lending disclosures below.
They're trying to tell
The
you,
truth in lending disclosures.
yeah, where are they?
Sorry, go ahead.
Where are these truth in lending? Where's the truth in lending disclosure? Where are they? I don't see them. I see other
Really?
things
Let
that try to look like it's that, but I'm not seeing any. Just,
Let
are
me
you?
check. Seller assisted loan.
A
Buyer may be required to pledge security. Oh, okay, it says NA. NA.
Oh, seller assisted. Oh, yeah. Okay. Is that a cosigner thing?
Buyer, I'm not sure. Buyer may be required to pledge security for the loan and will be obligated for the installment payments on both this
Retail
retail installment
sale.
sale contract and a loan. So what is this?
Oh, is there?
This isn't the loan. They're saying there's a difference. There's a difference between
Yeah.
a retail installment sale contract
Mm-hmm.
and a loan.
Yes.
And this is a retail installment sale contract.
Otherwise known as a disguised loan.
Yeah, like things that make you go,
Mm. And how it says, and the loan. Well, we didn't get that truth in lending, so where did the money come from? Other than, that down payment that this person put a down payment of $5,750. And this is a extension of credit.
So they're saying you're purchasing this contract.
Oh, the piece of paper?
They kind of say it up here a little bit. You, the buyer, may buy the vehicle below. By signing this contract, you choose to buy the vehicle on credit. You agree to pay the creditor the amount financed and the finance charge. We'll figure out your charge.
In U.S. funds. According to the payment schedule below, we will figure your finance charge on the daily basis. The truth in lending disclosures below are part of this contract. Con job.
Didn't we find something earlier that pretty much said that pretty much said what it said down here.
Don't you find that interesting that on this piece of paper here is talking about insurance and stuff like that? Because in Title 15-1605, it does say that insurance is included in the finance charges. And yet, if they have a written something on a piece of paper that it's not, that you do have to come up with something, I don't know, something in 1605. But see how convenient that this piece of paper, which is pretty long, by the way. It's a very long contract.
Quick question. I'm trying to understand since I just hopped in. What are we trying to establish here on the contract?
We're just dissecting it and seeing if we can find any violations, consumer violations or federal violations. Well, consumer is federal, but any violations within the contract.
To establish that we're not
supposed to be paying for it.
Right. There's one thing that I did pick up where if it was say for instance foreclosure.
One decision at a time. Order your copy today in your
Somebody
emotions.
has a hot mic. You got a hot mic.
If you go to court for a foreclosure and in court you put in an order for the bank to kind of bring in their ledger, their off ledger.
Yeah, the discovery.
Yes. So with that, let me see. I have wrote it down. That would show they, double bookkeeping and comes back down to 0. And there's hold on, let me find it. I have wrote it down. Yeah, it's a double. I think in public statute at large, 4848, 112, Title 12.
Okay.
Because if they if you put in an order, put in a recipe for them to bring in the off ledger to court upon, inspection of the ledger, it would show 0 balance because it comes back around. That's why, like before, I had picked up where it says like it always shows back to 0 because per, HJR 193 or 192, in there is in Title 12, Section 95A, there should be where the debt is no longer part of, the United States didn't start until 1871. So in 1865, the Banking Act of the United States of America, the original United States of America, where it has a revision interest of the United States and it has a debt, but it does state that there's no money, so you can't pay a debt and you have to discharge it. But I didn't really like look into it yet because I was like, just trying to
and being more mature and knowing the business now.
With that, you can actually put in an order at court to tell them to bring in the off ledger to court to show everybody for inspection, and it will show is a double booking entry and bookkeeping, and that will prove that there is a 0 balance on there. So I'm not sure that helps.
Yeah, if there's a 0 balance, that means it's been paid off. So what the heck are you paying for? You must be repaying them. And that's how insurance works, like car insurance.
Well, even when at your job, they secretly get life insurance on you without you knowing. Bank of America does it with the accounts. You remember with Bank of America, they made these secret accounts that took out like billions of dollars out of like hundreds of millions of people, and they got a bailout. So it's like, so you start thinking if it's already paid off and it's already paid for, where's the money? Well, looking at it, it's held in a presumed, trust account. And nobody ever claimed it. You have to claim it. So since you don't claim it, you had lost that rights where now instead of you being the creditor, you're the debtor because we never went in to claim or put it as a lien, or I wouldn't say as a lien, but
Where are
you
we
would have
supposed to
to
claim these?
put it
Because
under.
I've actually taken some of mine to the bank and asked them, hey, I think there's some violations here. I didn't get the truth in lending. And I put money down, and you're not supposed to mix that with extension of credit. And they send you back all these papers. Oh, look, we we're responding to your recent complaint in April and November and January and December and February and March. We did not find that you provided any new information that would change our response. And we've reviewed your account activity since our prior responses, and our decision remains the same. So we're going to close down your complaint. That's like with the banks, like this type of thing right here. And they just don't,
You put in a complaint with the
I
court, or
no, actually address the bank that with a particular car loan and a house loan, by the way. And they just keep going at it on the public side when I'm going the private way and sending registered mail, and they're just getting the public people to do the research, and they just keep denying it and go, no, it was, look, see, you got your name on a contract, it was a legitimate contract. I'm like, yeah, but you didn't give me the documentary evidence. And where did the money come from? Where's the ledger, both sides of the ledger? They don't even know about that kind of stuff. These people, they're the public. They're not
not at the bank. I don't think I think like a lot of people that I've heard, not that I've done it myself, because like I said, I'm still new into, but they did put like their, like say if it was a loan for the car, they will
Yeah.
put that under the trust and they put it into the bank account, and it becomes a little bit different because of how it's structured. But because then you're on the private side, right now you're still on the public side, so there's nothing you can really say to them, about things. And then especially with our words, it's like going into the courtroom. They have their own definitions and their own words that they dissect, and you go in there saying certain things, you're already in their jurisdiction.
Mhm.
So
You
it's
have to.
that's
I think if you're operating from the private side, you have to establish your relationship as private with them
right.
because they don't see anything private unless you explain the relationship to them. So you have to tell them that you're acting as surety for the principal debtor. Then they
Right.
already know that's how you separate yourself
Right.
from the public because the public relationship is a creditor debtor.
Yeah.
So when you come through the equity side, you're never the creditor because that's not the same relationship. Does that make sense?
Yes.
So only on the public side can you ever be a creditor because on the private side you can't act as a creditor
Mm.
because in equity doesn't redeem fraud. When you're on the public side, a lot of times you're trying to prove fraud. You see what I mean? So equity is out the question when you try to prove fraud because how would you redeem something in equity if you see what I'm saying?
Yeah.
So the relationship in equity is always that you're never the creditor. You're
Okay.
always the surety. So what happens is I think I put a post on the site, and what I try to explain to people because I didn't want to put it out of what it meant when I said that you're never the creditor in equity. So I'll just explain it real quick. You're never the creditor because if once you say you're the creditor, then natural law says that the opposite of creditor is debtor. So that in itself is a relationship that's public. It's never private. As private, when you're claiming equity, because remember, what you're trying to do is you're trying to merge the two titles. You're trying to merge equity title with legal title. And when you merge them, that's how you settle the debt, because now both sides are merged. But when you're not merging both titles and they split, legal title goes to you and they get your equity. And the reason they get your equity, because every promissory note or document you sign, it's your signature that's giving that document equity.
Right.
And what they're giving you in exchange is public credit. Does that make sense?
Yes.
Mhm.
So
And
the
that's
key
why
in
we
equity,
have,
so the key
well,
in equity when you go to court is that the document is more about the document and not so much credit, debtor, or relationships, because the document is where the equity is. So when you sign for your house, that document is the equity. So when you sign it, they'll say, hey, we're going to take your promissory note for collateral.
Mhm.
Once you give them the equity, they give you the public credit. And that's how everything becomes public, because you're not protecting your signature on the private side. When you sign the document for equity, you're supposed to give notice of equity and notice of what they call equitable subrogation. That way they can't say, hey, you didn't make it clear when you signed this contract,
Mm.
because you only have 72 hours under truth in lending to cancel a contract.
right.
Nobody does that in 3 days. It
Yeah,
takes usually 3 days to process something,
this contract says
you
there's
know.
no
So,
cool off period unless you obtain a contract cancellation option.
right. So, but again, what they're talking about is the straw man. So on the public side, what you're supposed to do on the public side is you're supposed to make a decision on whether you want to file your indemnity through the birth certificate, because that's really the game here. It's public and private, but they're both dealing with the principal debtor, which is the birth certificate. It's just the public deals with the birth certificate differently than the private does, because the private, your position is always the surety. As surety, you're never the creditor, but you have creditor rights because you're dealing from private. You're the only one bringing equity to begin with. They're
Why
not
would you
bringing
be
anything.
surety when you can be beneficiary?
What's that?
Why would you be surety when you can be beneficiary?
Because
Well,
as surety, you
people
are the
are source
beneficiary.
of all wealth. I figure the people are source of the wealth, right? So you yourself are wealth.
Well, the wealth comes, well, if you're dealing from equity, you got to remember, equity comes from God. So you're
Right.
never the creditor. The Lord is the creditor, but you're the surety. And as surety for the principal debtor, you have to walk through their stargate in order to get the redemption. So you have to base, this is basically why in equity they use equity maxims in Bible scripture,
Right. Right.
because in equity, what you bring to the court, it has to stand without statute and code. If what you bring to the court can stand without you using the statutes and codes, which are public, they will see you, because Article 3 in the Constitution guarantees that they see equity and trust. And you can only extend that from the private side. You can never extend Article 3 to the public, because the public belongs to the military. And this is what they tell you in Article 1 and Article 2. You see what I mean? And it's right there for everyone to read.
Mm.
It's,
Yeah.
if you read Article 1 and 2, that's public, that's military. If you read Article 3, that's private, because private Article 3 deals with equity and trust.
Mm.
So you have to establish your relationship, and you have to know what the difference of in relationship is, because you're not allowed to mix, because God said you can't serve two masters. You're either serving Caesar, which is man's law, or you're serving me, which is God's law. You can't mix the two. So you can't use Caesar's codes in God's world because he doesn't see it. Just like you can't use the Bible in the public world because they can't see it. Because remember, the maxim in the public is he who creates controls. They created that system, public system, using public policy. You see what I mean? So they're God in that system. So you have to deal with them in accordance. That's why I said the biggest decision people
You
have to
got a
make
hot
when doing
mic.
the process.
I think maybe. Okay, sorry. Go ahead. Maybe it's mine.
And so this is why, I don't know if you guys heard Yusef say it, Yusef said the biggest thing that you have to decide when doing the process is, where do you want to operate? Do you want to operate publicly, or do you want to operate privately? Once you make that decision, then you can focus strictly on, okay, I want to deal with public. Okay, I got to learn statutes and codes. So I got to learn commercial jurisprudence or commercial law. If I want to deal with equity, okay, I got to deal with equity. So I'm dealing with God's law, equity maxims, and equity jurisprudence. They have this, it's two law books, but you have to decide which one you want to go. Because once you start mixing the two, you're already disqualified
Well, they're going to
yourself.
mix them for you, and you've
No,
already
it's not
mixed
up to
it.
it's not. Yeah, it's not up to them. It's up to you. Because remember,
I mean, you've already mixed it. When you go and sign a contract, you create the event. So, I mean, you've already mixed it. I mean, and that is
because
where you find your equity at.
Well, no. Remember when they bought you the contract was public. Because remember, before anything can become public, it's private first. So you always hold the equity, always. And when you sign the document, you still hold equity as long as you protect your signature. Just like if I tell you, hey, how do you protect your signature in the public? You're going to tell me, well, I signed this, UCC 1-308. It's the same thing with equity. You always have to give notice on your signature to whatever document you sign, because as long as you give notice of equity, you keep the equity. It never goes to the private. But the problem is because you don't protect your signature. Once they give you the public credit in exchange for your equity, which they hold in collateral, the game's over.
Right.
So you see what I mean?
Yeah. So when you say protect your signature, in what ways are you protecting your signature to show that you are coming in equity?
Yeah, you have to give notice. So, like, say, for example, if you wanted to take a $50,000 loan, they say, okay, hey, we ran the paperwork and they approved you. We just need you to sign right here. At that moment, you give notice of equitable subrogation at that moment, which means you're going to circle your name, establish your relationship as the surety. You're going to circle the all caps name, and you're going to establish the relationship that is the principal debtor. The creditor is the state of wherever you live in. They're the creditors. They only have a superior right that goes as far as what they call a subrogor. But your right as a surety is higher than their right because you bring the equity, they don't. So you would be known as what they call a subrogee. So a subrogee has creditor rights, but you're never the creditor though. Because you're a child of God. God gives you the equity, and you are allowed to use from the tree of his fruit, but you can't say it's yours. Because remember what they said in the Bible, whatever you say above stands below.
Yeah, so it's above.
So when you say, hey, I own this car, you're really telling God upstairs, well, I own it up here too. And that's when he walks away from you. So that's the trick with equity. Equity is like, you always got to stay within the Bible, and you always got to stay with equity maxims.
It's mindset. It's mindset first.
Yeah.
That's pretty much all
exactly.
it is. That's what you're saying. And when you say, and when you go to, that's why it's sometimes a little hard, but I've been doing it so long. It not have been that long, but I can kind of understand. 1 second. When you say sign to separate it, that's kind of what I do. That's what I do. I sign, I write, all caps, comma, agent. And then right under it, it's like a lowercase comma beneficiary.
Yeah, and like I said, if you're signing for the public, like I said, signing for the public, yeah, but when you're signing in the private, you're always a surety because that's what they imply you to be. They imply you to be the surety for that principal debtor. The problem is they know the principal debtor's insolvent. They know it can't pay anything. They know that in the private, everything's paid for because the private side is where the equity happens.
They don't know.
I'm just saying, yeah. I'm just saying the private side has the equity. The public side has the legal title. So what happens is you're giving them equity, and in return, you're getting legal title. You don't want legal title. You want equity because that's where they got the value from in the first place.
Yeah, for the interest that need to
be. Yeah,
because
you want
All right,
for
I got
interest.
a quick question real quick. Isn't that
Okay,
why
go ahead.
you file a 1099 OID? I'm sorry, I cut the other lady off. I know she needs to ask that.
1099 OID.
Yeah,
Who's
because
that?
I heard that when you file, all right, when you get a car loan or something like that, because it is an interest, right, that needs to be returned back to the principal, to yourself, right?
Mm-hmm.
That's what I've heard, that the 1099 OID, the OID is to identify the funds, and then you file your tax return. But say if you put a house in, right, like every year you got the tax, well, the tax got to be filed the following year or whatever, the next year, but the interest will still be in there. But that's why you file it, because you have to collect that interest coming back to yourself, because if you never claimed it as yours, then and then with the facts that you had to do the 1040, because like he said, you get a title, but you don't get the full title. So if you wanted the full title, then you would have to do a 1040 form, which is simply a salvage claim. So I wanted to ask him, you know, have he ever heard of that, or like, have he ever done that with,
I personally am not messing with the IRS forms, but
Yeah,
so
I
let
mean, me personally, the way I wouldn't mess with them either. I mean, I'm not trying to tell nobody how to do their
right,
thing if
right.
you're operating publicly, but as far as me, once you give notice on the promissory note, you own the equity. That's the whole point. Think
Okay.
of it
So you
like
don't have to
this.
really cut right, right,
What's
right. I see what you're
what
saying.
you see what I'm saying? What's the most important thing here? Is it the
The
equity
ex-
or is it the credit they give you in exchange for the equity? Because like on the loan, there's a document that says, "Hey, here's the application or a promissory note that says we're going to give this man or woman $50,000." Okay, once you give notice of the equity on that document, the document is the only thing worth value. Everything else is nothing. The credit that they give you, the 50,000 in credit they give you to hold that in collateral, that's nothing. All that stuff is nothing. What's important is the collateral, because that's the only thing that has equity, and that's what's driving everything. Does that make sense?
Yes, yes.
My
And
question
that's why you have to protect that document.
was back to the signature.
go ahead.
Would we be saying by our name in lowercase / agent, and then under it, would we say for the all caps name / principal, and then without recourse on all of these little points? Like, look at how many times this particular thing was signed. We're going to do that with every single little area? Or are we circling something you said?
Well, especially anything that requires your signature must be protected, because when you don't protect your signature on anything you sign, it becomes a loophole for them to explore and escape. This is why you have to protect your signature. Anything that's asking you for a signature, you have to protect it. So how you protect it in the private is simply by giving them notice, because again, whether you're coming for public or private, you always have to notice people, whether it's the court, whether it's the credit companies, no matter who you're dealing with, you have to give them notice of how you're coming.
Oh, you
And
mean
once they know, hey, it's equitable subrogation.
with a piece of
Yeah,
paper?
see, so if you're coming privately,
Mhm.
no, you would sign the document. You got to remember, any document you sign, your signature is giving it equity. So, but what they do to trick you is they say, okay, thank you for signing this equity that has the $50,000 on it. And then they say, in exchange, they're going to give you $50,000 of public credit that has really no value. And then they
It's
make you
just
pay them
that.
back twice.
Yeah, we got 7 minutes. I would
So
like to chat about like the differences between surety and beneficiary, but maybe on
the surety is the beneficiary. It's just one of the benefits of being
so why
God's
would you
child.
choose surety over beneficiary?
Because again,
Surety
remember,
is like
we're talking private. What it
but
means in
surety is
private,
like responsible party, where
yes, for the principal.
beneficiary is
No, no,
like,
no, 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 no. It's responsible for the principal debtor.
Yeah.
See, you
why
get a
would you
straw
want
man,
to
I
be
get a straw man.
responsible for the principal debtor?
What do you mean? Why would you want to be responsible? Because you are. It's the only way you can redeem your equity.
It's not your
You see what I mean?
obligation.
But
No, it's not your obligation, but because they operate publicly and you haven't made it known to them, You haven't done anything. You haven't ran an abatement. You haven't done anything to tell them
You're
otherwise.
still on
Because
the
remember, in the
side.
public, they operate under assumption and presumption. You have to correct the assumption and presumption, and that's why you give them notice saying that, hey, I'm the surety, because they're implying you're the surety. So this is what the Bible says: accept the charge. Once you accept the charge, then you come under grace, and God provides the remedy. You just have
I
to walk through
understand.
the public stargate to get the remedy, and that's the hard part. Nobody wants to pick up their cross and walk
I
through the
understand.
crucifixion. You
So
see what I mean?
it's not your obligation, but you are taking responsibility because you are responsible for creating the event.
You are doing business
Yes.
as the straw man.
Okay.
Because the
I like
public,
that.
remember, it was public first, it went to private. So what you're trying to do is separate the two titles, say, hey, I want to come back to the private and leave the public. Basically, you're saying you keep the legal title, I keep the equitable title. If I want to settle things in the public, I can use my equitable title and merge it with their legal title to settle the issue. That's how to discharge the debt. Because you can really truly only discharge it from God's side, because God has the positive, they have the negative. But that's why I said it's the first decision you have to make is, do you want to use statutes and codes and play their game, or do you want to play the private game and stay on God's side and use equity and Bible scriptures to protect yourself from these contracts? Because the right to a federal common law contract was done away in 1917 or 1918. But I just
Say
don't say
again?
that. The right to contract federal, it started in 1917, 1918, and then it was done away 1935, I believe. Erie versus Railroad. I'll post it. I just don't like posting stuff because a lot of times when I'm posting stuff, people come with negative energy, and a lot of times it's because people don't want to read or study themselves.
Mm-hmm.
I think it's called Erie,
Versus
ERIE.
railroad. So if we
Which
wanted
is versus the railroad. Yeah, that's the one.
if we wanted to repent and go back to those dealerships, how would we go? How would we cloak ourselves to repent? If we're not going to say, hey, I got violated, we're not going to say that, and we're not going to use the titles and codes, then how would we go?
Couldn't you just simply say, I made a mistake and you want to recontract? Or do you
Correct.
just give notice of equitable subrogation?
Yep, that's what you would do. Because again,
Okay.
that's the only way but that's only if you're operating privately. So I can't
Right.
speak on public
On
remedies because I
everybody,
don't,
right.
you know what I'm saying? So I don't want to steer
Yeah, I'm
people
saying
wrong that
so.
are operating publicly. I don't want to mess them up.
That's the truth.
So we
Because
want to go privately.
if you're
So we're not going to be
then
mentioning.
give notice of equitable
I thought that those people who mentioned those things were actually saying, you guys need to follow your own rules because your own rules, you violated us in that way. But I understand what you're saying. If we want to go privately, then we would have to give notice, sending something registered mail to CFO.
Yeah, you can when and you always want to use the United States Postal Service, because once you use the USPS, then you have the authorization of the worldwide postal service. Again, it's something I posted on the site if you guys want to go look at it. But the reason you want them is because once you have their authority, if the postmaster doesn't act right, you can take your matter to them, and once they correct your matter, because the reason you're doing it is because
2 minutes.
the reason you're doing it is because you want to become postmaster on your own contracts. This is why, but I don't want to explain everything, because if I explain everything, people won't read, and you have to read to get it yourself. This is why I
Yeah, it
only
becomes
throw a
overwhelming
tidbit
when
out
it's a
there.
lot of information.
What site were you making reference?
Right, and that's why I only give you a little bit. I give you a little bit. I use the private, but that's me. I don't know if you don't operate privately, I wouldn't listen to what I'm saying unless you're operating privately or you want to attempt to operate that way. Because like I said, there's always two modes of operation, public and private. You just have to decide which one you want to do. One side files their indemnification clause under their birth cert.
Private.
The other side says, no, I want my equitable title back. It's just on you
No,
guys.
I want to be on the private side.
What site were you referring to, brother?
What site was that?
Mm-hmm. That we can learn about
The private side that's where yeah, but it's again, that means you have to unlearn everything that you learned from the public side, and that's not easy to do too. I mean, imagine the 12 disciples walking around telling everybody, hey, we're private, amongst all these people operating publicly. It wouldn't,
If
you know
less
what I
than
mean?
a
That's a lot
minute,
to take
Everybody,
in.
everybody been telling me like it sounds like I'm being
can you
scammed.
drop
I'm
the
like, okay, yeah,
site
whatever.
for us? Tell us.
The website.
Yeah. Well, remember the rule. God created man, man created government, government created the US citizen.
Right.
Just think about that. And he who creates controls. That's a public maxim.
Mhm.
Caesar said, hey, I created this system, therefore I own it, which means you can't tell him what to do in his system. You see what I mean? Unless
That's
you're
why we
using the
have our
correct
own set of
statutes and
law.
codes.
Yep.
Yeah, and that's not easy. You know what I mean? But
Well,
again,
every
I don't tell
family
nobody
has
how to
their
do it.
own law that they run by. So if
What
you're in a
site
private, you would
were
have
you
been